to begin. So whenever you are ready, this round is good to go. You can begin. To begin.
Good afternoon, Your Honor. Before I begin, I just want to make sure you can hear me okay. And may the plaintiff make appearances, Your Honor. I believe
Archie, we can't hear you.
Okay. Sorry about that. I will say, just so we're all clear, all law seems to be around 12:50 p.m. Central Time. Go ahead and make appearances, plaintiff.
Okay. Good morning, Your Honor. My name is Emmanuel Soto, and I'm joined today by my co-counselor, Ms. Jelly Canales.
Good morning, Your Honor.
Ms. Chloe Solis.
Good morning, Your Honor.
And together, we're advocating on behalf of the plaintiff in today's case, the estates of Genesis Petrillo. Your Honor, seeing as this is our first time in your court, we would like to address some housekeeping matters. Would you prefer that we request permission prior to displaying exhibits and demonstratives for you and opposing counsels to view them?
Yes, please.
And Your Honor, may we presume that all objections and subsequent arguments are constructively heard outside of the earshot of the jury?
You may.
Additionally, we would like to verify that a bench book which may be useful to you when deciding on issues that arise during the trial has been given to you. It should have a copy of the Millen's Rules of Evidence, the complaints and answers, stipulations, relevant case law, and the pretrial orders, all which opposing counsel has already seen. Then, we would like to invoke Rule 615, constructively sequestering all witnesses. For the purpose of this trial, our party representative is P&E Estates. And Your Honor, we would also like to invoke Rule 603, pre-swearing all witnesses before trial. Then, we would like to address some stipulations, specifically Stipulation 3, that states that Exhibit 1, 2, through 10 are pre-admitted. We would also like to make the court aware that the plaintiff is calling Lonnie Paris, and that under Stipulation 4, Exhibit 11 is also pre-admitted. Next, Your Honor, we would like to go over some case law, specifically Kaplan v. Socorro, 2013. It is our understanding that under Rule 801D2D, any statements made by the party opponent or any employees of P&E Estates are an exclusion to hearsay. Next, we would like to
Hold on. You're going a little too quickly. Do you mind pointing to the case law once again?
Yes, Kaplan v. Socorro.
Do you mind pointing out the page number where that appears?
I do not have the page number of where it appears, Your Honor. But it should be on the case book.
Do you mind repeating the name of that?
Yes, Your Honor. Kaplan v. Socorro, 2013. I believe, Your Honor, it's in page 4.
Yes, I just found it. Do you mind repeating what your understanding of this rule is? What this case is?
Yes, Your Honor. It is our understanding that under Rule 801D2D, any statements made by the party opponent is an exclusion to hearsay.
But you said a little more than that, didn't you?
Yes, P&E Estates and its employees also fall under the party opponents.
Just to be clear, defense, is that your understanding of this case as well?
Yes, Your Honor.
All right. Plaintiff, you may continue.
Thank you, Your Honor. Next, we would like to go over some pretrial order. We would like to note that under vicarious liability has been granted and that the plaintiff has moved to hold defendant P&E Estates vicariously liable for the conduct of the following P&E Estates employees: Harper Martini, Austin Lewis, and all other employees of P&E Estates. And then lastly, I'd like to direct your attention to the complaint, which can be found in the bench book, in which It was established in points 16 and 22 that the elements 2 and 4 of negligence per se have already been satisfied, and therefore only 2 elements are in dispute today. With that, Your Honor, the plaintiff is ready to proceed.
Just so we're clear, you noted that the party representative in this case was Peony Estates. Are you saying that's your party representative, plaintiff?
Yes. No. Sorry, Your Honor, no.
So do you have a party representative for your side?
No, not for plaintiff.
Okay, thank you for the clarification. Defense, do you have any other pretrial matters to attend to?
Good morning, Your Honor. My name is Stephanie Jimenez, and I am joined by my co-counsel, Leslie Garcia, and Razan Elsadig, representing the defense in today's case in chief for Peony Estates. Before we begin, we only have one pre-matter trial, which, Your Honor, may the defense have a 5-minute recess after the defense case in chief, if time permits?
We'll see when we get there, but I would be amenable to a recess between cases in chief and after the defense case in chief.
At this time, the defense has no further pre-matter trials to address.
Just so we're clear, do you have a party representative?
No.
Okay. All right. If there are no further pretrial matters, plaintiff, you may proceed with opening statements.
Yes, Your Honor. May it please the court. Unsanitary conditions led to unacceptable results. Members of the jury, today's case is all about standards. And today you're going to learn about the standards our city of Midlands has and how the defendant, Peony Estates, failed to meet those standards. On June 7th of 2019, you'll hear that there was supposed to be a wonderful wedding rehearsal. However, you'll also learn that that never happened because of the actions taken by the Peony Estates' employees. You see, Peony Estates is a winery located right here in Midlands. And today you're gonna learn how they had trouble managing the storage of their pesticides and how their carelessness ultimately led to the death of Genesis Petrillo, which brings us here today. On June 7th of last year, Harper Martini, the owner of Peony Estates, prepared a bottle of 2019 car wine for Miss Petrillo as a gift. However, testimony will show that this bottle of wine had been contaminated with pesticides, specifically isofenfos. Today, you will learn about all the unsanitary conditions at Peony Estates, which ultimately led to the unacceptable result of Miss Petrillo's passing. After being the only one to drink from that bottle of wine, Miss Petrillo sadly passed away due to pesticide poisoning. Testimony will show today that Miss Petrillo's blood and stomach contents tested positive for the same pesticides found at Peony Estates and in the wine bottle. Members of the jury, what is absolutely crucial to today's case is the Midlands Buildings Code. Members of the jury, this code is what governs what places like Peony Estates are supposed to do in order to ensure that people like you and me are safe. Today, we are going to show how Peony Estates violated this code on several occasions. In order to do that, we're going to call 3 witnesses to the stand. First, you will hear from Mr. Lonnie Parras, an investigative journalist who will tell you all about Peony Estates' trouble managing their pesticides, specifically with their 2018 grapes, and how that would have affected the 2019 bottle of car wine. He will also tell you how he witnessed bottles of pesticide near that bottle of wine at Peony Estates. Second, you will hear from Mr. Sam Arnold, the hired caterer for the wedding in question today. He will tell you how he witnessed pesticides in the Peony Estates' kitchen, bottling area, and near the bottle of 2019 car wine on June 7th. And finally, we will call Riley O'Keefe to the stand. an FDA inspector who will tell you all about Midland's Buildings Code and how he witnessed the unsanitary conditions at Peony Estates, including pesticides near the bottle of 2019 car wine that was drunk by Genesis Petrillo. Now, in pursuing justice for Ms. Petrillo, we bear a burden in today's case. We must prove that Peony Estates is liable for negligence per se by a preponderance of the evidence. Now, opposing counsel is going to get up here and try to convince you that this burden is very difficult to meet, but it won't be today. You see, all our burden is asking us to do is prove that Peony Estates is more likely than not liable for the violations of the Midlands Buildings Code. And we have to prove three things. First, that they violated the code. Second, that the defendant's acts and/or omission caused the type of harm that the code was intended to prevent. And third, that these violations were the direct and proximate cause of the harm suffered by the plaintiff. And today, we're confident that you will see that the unsanitary conditions at Peony Estates led to the unacceptable result of Ms. Petrillo's death. And it's for these reasons that at the end of today's trial, my co-counselor, Ms. Chloe Solis, will come before you and ask you to find Peony Estates liable for negligence per se. Thank you.
All right, thank you. Defense.
May it please the court. Precautionary measures lead to preventative results. A picture-perfect room, decorated in flowers and laughter, all hosted by Peony Estates, a winery located here in Midlands. The night quickly takes a detour to the emergency room, and Peony Estates is being held accountable for the death of Genesis Petrillo. See, members of the jury, Peony Estates did no harm to Genesis Petrillo. The plaintiff has and will paint a completely different narrative. Today, you'll hear the real story of Peony Estates. Good morning. My name is Razan El-Sadiq, and today I'll be representing Peony Estates alongside my co-counsel, Stephanie Jimenez and Leslie Garcia. The plaintiff has sued Peony Estates under Midland's Pest and Pesticide Rule, also known as Rule 12-100. See, Peony Estates' story doesn't begin with Peony Estates. It begins long before, when the owner of Peony Estates excelled at her job as a vineyard manager at another winery located here in Midlands, also known as Rosie and Pedro's. See, Peony Estates had to use pesticides due to the insects consuming their property, pushing away customers, ruining their harvests, and ultimately jeopardizing their business. Peony Estates hosted a rehearsal dinner on June 7th, where the owner spared absolutely no expense, hired the best wedding planner they knew, and the best chef they knew. They even offered the bride with the newest wine, Cara, enriched with the winery's finest Petit Verdot grapes. See, the Peony Estates had many precautionary measures prior to the rehearsal dinner. Every time a health inspector came, they fixed their mistakes and they were cleared for business. Members of the jury, if Petrillo never died, but still took that trip to the hospital, the plaintiff would still be pursuing this case today. Today, we're not speaking on the grounds of guilty or not guilty. We're simply speaking on terms of liability. The defense has no burden to prove whatsoever, but the plaintiff has to prove every bit of their argument by preponderance of the evidence. In other words, they need to prove that Peony Estates needs to be held accountable by the harm suffered by Petrillo and the Petrillo family. And they won't be able to meet this burden today. Today, you'll hear from Austin Lewis, an employee at Peony Estates. He'll tell you all about the precautionary measures that the winery went through to ensure they were in tip-top shape. Next, you'll hear from Danny Francasio, the owner of Rosie and Pedro's. In fact, he was Peony Estates' competitor. He'll come up here and tell you about how the owner of Peony Estates contacted her competitor for advice with the pest issue. And finally, you'll hear from Dr. R. Cannon. He'll tell you that Petrillo's death could have been due to several reasons, even including alcohol poisoning. I want you to picture a bottle of wine. Our job as the defense is to place little cracks in this bottle of wine to prevent it from filling up. Today we ask you to pay attention. Pay attention and listen. Listen to how Peony Estates took steps to ensure everyone's safety. Listen to how they complied with all the health standards set forth by the health inspector. Today, you're gonna learn that Peony Estates started their day of June 7th, much like had they done the rest of their time at the business. Knowing that precautionary measures lead to preventative results. Results that ensure everyone's safety. And when you find that the plaintiff is unable to meet their burden, we ask you to find in favor of the defense and find Peony Estates not liable for the death of Genesis Petrillo. Thank you.
All right, thank you. Plaintiff, call your first witness.
Your Honor, at this time we call Lonnie Paris to the stand.
All right.
And before we begin, I just want to make sure you can hear me okay?
Yes.
Your Honor, I want to make sure you can hear me as well.
Yes, I can.
Please introduce yourself to the court.
What's up? I'm Lonnie Paris, and I'm an investigative journalist.
Can you tell the court what an investigative journalist is?
Sure. Investigative journalism is just normal journalism, but with higher stakes. We're the people you see going into war-torn countries and telling the world what's really happening on the ground.
So, how are you related to this case?
I investigated Peony Estates for possible health code violations and pesticide use.
When did you receive this tip?
In 2016, I received an original tip from Danny Francasio. I didn't start investigating until around 2018.
Why did you wait to investigate Peony Estates until 2018?
I had a pretty heavy workload, and then I got let go due to the recession, and I needed to...
Relevance?
Response?
May I have a response, Your Honor?
Go ahead.
It is how Lonnie started her investigation is really relevant to today's case because it will make the facts more irrelevant.
What facts will it make more relevant?
Well, through her investigation, you'll be able to see what she discovered in Peony Estates.
How does his testimony make that more or less likely?
It's laying the foundation for her to be able to speak on behalf of what she saw at Peony Estates.
You got to make that a little more clear to me. How exactly does these facts make it more or less likely whatever he found at Peony Estates?
It makes it more or less likely because it informs how she started with the investigation, why she decided to start the investigation, what tips she received to do so.
I'll overrule.
I'll re-ask the question. How did your investigation start?
Well, in 2016, I received the initial tip from Danny Francasio, but I didn't investigate until 2018.
Did you learn anything when you toured Peony Estates?
Yes. I toured on July 13th, 2018. I walked around the premises and I didn't really see anything of note. So a couple days later, I took a guided tour so I could get inside the facilities.
And When you were in the facilities, did you see anything worth noting?
Yes. While I was on the tour, one of the employees of Peony Estates, Drew Matsukas, told us that wine is made from grapes harvested a year earlier, which means
Objection. Hearsay.
May I have a response, Your Honor?
Go ahead.
Under Rule 801 D2D, any statements made by employees of Peony Estates are exclusions to hearsay.
Response to that?
No response, Your Honor.
In that case, overruled.
You may proceed.
As I was saying, Drew Matsukas told us that wine was made from grapes harvested a year earlier, which means grapes that were harvested in 2018, you would find them in a 2019 brand. Also, I hung back on the tour and I snuck into the employees only section, and I found a memo from the head winemaker, Austin Lewis.
Would you recognize a copy of Austin Lewis's memo?
Yes, I would.
Your Honor, permission to show Exhibit 12 into the screen for opposing counsel and the witness.
You may.
Objection. Hearsay again.
We'll get to that when the plaintiff offers this into evidence, but for now, just hold off.
What have I just shown you?
This is a memo that I found from the head winemaker at Peony Estates, Austin Lewis.
Is this a fair and accurate copy?
It looks to be.
Has this been changed or altered in any way?
Doesn't appear to be.
At this time, Your Honor, we offer Exhibit 12 into evidence.
Any objections?
Yes, Your Honor. Two objections, hearsay and lack of personal knowledge.
May I be heard, Your Honor?
You may.
Further hearsay objection, again, under Rule 801 D2D, any statements made by employees of Peony Estates is an exclusion to hearsay. And what was the other objection?
Lack of personal knowledge.
And as to lack of personal knowledge, she's Lonnie Paris isn't making a conclusion of the statement. He's just making an observation from the statements.
Response, defense?
Your Honor, I'm simply just asking the opposing counsel that Lonnie Perez did not know about this piece of information. She doesn't have knowledge of this letter, excuse me.
May I have a response, Your Honor?
Go ahead.
In her previous statements, Lonnie Paris stated that he found this memo when he was doing the tour, therefore giving foundation as to why he knows about this memo.
Final response, defense?
No response, Your Honor.
In that case, objection overruled. This exhibit is admitted into evidence.
Yes, Your Honor. What did you learn from this memo?
Two major things. The first is that Peony Estates has a pretty serious problem with pests and mice, which would confirm why I had seen pesticide lying around the property. It also said that they were going to be using that pesticide soon. But what really stuck out to me is Austin says that the spraying must be done quickly and cheaply. Nothing else matters. Personally,
Objection.
I think safety matters.
Narrative.
Overruled.
Thank you, Ms. Canales. We can remove the exhibit from the screen now. What was your next step in your investigation?
I went back home and I looked over all of my notes, and I realized that the initial tip I had received from Danny Francasio kind of jumped the gun. He sent it in 2016, which is when they started using pesticides. The effects weren't seen until 2018. But if I wanted to catch Peony Estates in the act, I had to wait until 2019.
How did you restart your investigation?
I returned to the property, and of course, with seeing a lot of pesticides on the property, I overheard some of the employees talking about an inspection that was coming up. So I called my friend at the FDA to confirm the time, and he said it was a surprise inspection. which kind of stuck out to me because how would they know that they had a surprise inspection coming up?
Did you ever return to Peony Estates?
Yes, I did. I returned the day of the inspection. And what was really interesting is that all of those pesticides I had seen lying around in 2018 were just magically gone for the day of the inspection. Unfortunately, I ran into Austin Lewis, and he recognized me as the guy who'd been sneaking around for a year and a half, and he had kicked me off the property.
When Mr. Lewis kicked you out of the property, did it halt your investigation?
No way. You cannot stop the machine that is investigative journalism. I returned to the property the day of a wedding rehearsal, and I went into their wine cellar, and I found this 2019 bottle of Cara wine. What stuck out to me about it is I had seen that exact same bottle sitting in that exact same spot in 2018, surrounded by pesticide canisters.
Would you recognize the picture of the Cara wine?
Of course.
Your Honor, permission to show Exhibit 2A.
I believe it's on the screen already.
Is this the bottle of wine you saw sitting on the shelf on your previous visit?
Yes, it is.
How did you know this was the same bottle?
There's a pretty neat little label on it.
Permission to share Exhibit 2B onto the screen.
Go ahead.
Is this the label you saw on the bottle of wine sitting on the shelf from your previous visit?
Yes, it is.
Thank you, Ms. Canales. You can remove the picture now. Was the bottle of wine open?
I'm not 100% sure, but I know I would definitely have remembered if it was closed, because there's a little cork in it. But what really stuck out to me is all the pesticide I had seen lying around it.
Now, I want you to direct your attention to the bottling area. Did you ever come back to investigate the bottling area?
Yes. After I left the wine cellar, I went into the bottling area, and it's where I found my big discovery. There was this canister sitting next to the bottling station. There was no label on it, but it looked like the bug-off pesticide I had seen them using on the property. So I took a test of it, or took a sample of it, and I sent it for testing.
Speculation.
Do you mind explaining a little more?
There was no way the witness could testify to him thinking it was the same bottle of wine that he saw there.
Response?
May I have a response, Your Honor?
Go ahead.
He is not speculating. He's using his rational-based perception to be able to infer that it was the same bottle.
Response?
Go ahead.
Your Honor, it's a winery. There could be several bottles of the same brand. It could have been replaced. The witness has no knowledge of that.
That sounds like something that you can bring up on cross-examination. But for now, as far as what the witness rationally perceived, as long as it's within that scope, I'm going to allow the testimony. But feel free to raise that point on cross-examination. For now, overruled.
Yes, Your Honor. Did you ever see the employees wearing gloves during your tour?
No, I didn't see them wash their hands.
Did you see anything else worth noting?
Not the day of the rehearsal. On the next day of the wedding, I received some pretty terrible news.
What news did you receive?
I heard that one of the wedding guests had been rushed to the hospital, Genesis Petrillo. I followed the other guests to the hospital, and I heard the doctor say that Genesis died of pesticide poisoning.
You mentioned earlier that you sent a bottle for testing. What were the results of that report?
There was a couple results, and they were pretty insightful. But what also stuck out to me is my friend sent me a second report of a wine bottle that they tested on Peony Estates property.
Would you recognize a copy of that report?
Yes.
Permission to share Exhibit 11 onto the screen.
Go ahead.
What did you learn from this report?
What I learned is that, let me clarify. This report is the one of that canister I found and I sent for testing. What really stuck out to me is all the chemicals it's tested for come back with a low amount, except for isofenfos, which came back with a high amount.
Now, I want to talk about the second report. Would you recognize a copy of that report?
Yes, I would.
Your Honor, in proper opinion, this is not an expert to give their testimony.
Response?
Yes, Your Honor. He's not making any conclusions from the report. He's just stating an observation made from that report.
Defense, exactly what part of the witness's testimony do you think requires expert knowledge?
Well, the exhibit they just displayed, it is an exhibit that only a expert can testify to in that field. Although the witness may understand it, they don't have the capability of explaining it to a jury.
May I have a response, Your Honor?
Just to be clear, the witness was just reading what it said on the exhibit, correct?
Yes.
In that case, defense, did you have a problem with the witness reading off of that exhibit?
Your Honor, I just simply ask that if the witness should be able to fully interpret what is on the exhibit in order to read off it in case there's any extra interpretation.
May I have a response, Your Honor?
No need. As far as I understand, the witness was just reading off of the exhibit, but I agree if the witness does try to start talking about his own conclusions or interpretations of that exhibit, those would be inadmissible. So for now, I'll overrule the objection, but if you feel that he is offering his interpretation, you may re-raise the objection.
Yes, Your Honor. Now, I want to talk to you about the second report. Would you recognize a copy of that report?
Yes, I would.
Your Honor, permission to show Exhibit 10 onto the screen for opposing counsel and the witness.
Go ahead.
What have I just shown you?
This is a copy of that report that my buddy at the testing lab sent me. It's a report of a wine bottle that they found on Peony Estates premises.
And what did you learn from this report?
As you can see, all of the chemicals it was tested for came back with a low or a medium amount, except for isofenfos, the exact same chemical that also tested highly in the pesticide chemical chart.
And lastly, for the jury, what is isofenfos?
On all bottles of pesticide, there's a warning label with the
Objection.
chemicals inside of it.
Yes,
Objection, Your Honor. I'm not sure if you can hear me.
I can hear you.
Again, in proper opinion, the witness is unable to testify what isofenfos is. He's not a witness. He's not an expert witness, excuse me.
May I have a response, Your Honor?
Go ahead.
He visited Peony Estates multiple times and has been in close contact with this pesticide. He was able to know what isofenfos is because he read the label, the warning label.
Response, Your Honor?
Let me clarify something. Plaintiff, I don't think the witness has gotten to it exactly yet, but do you mind proffering what he's going to say about what isofenfos is?
Yes, Your Honor. He will say that isofenfos is the main chemical of bog-off pesticide, which he was able to learn because he read the warning label of the bog-off canister.
Response, Your Honor?
Go ahead.
Your Honor, if he read the label, this is also hearsay. Again, just because someone did prior research does not qualify him to give their opinion.
Okay, let's handle the hearsay objection then, since we already brought it up. Plaintiff, what's your response to the hearsay of the label?
The hearsay of the label, Your Honor. So with this, we're not trying to prove the truth of the matter asserted, but instead of the subsequent action on Lonnie Paris.
Response?
Plaintiff, clarify what's the subsequent response.
That while reading the warning label, he was able to further investigate what isofenfos was.
Defense, your response?
Your Honor, they are using this for the truth of the matter. If the label, if the words on the label were not true, or they wouldn't do prior research, they wouldn't go out of their way to look up information on what isofenfos is.
I'm tending to agree. So I think we've established that this witness does not have personal knowledge of what's in the pesticide bottle or pesticide spray because he read it off of something. And even if we tried to admit that label that he read off of, that would be inadmissible hearsay. So I'm going to sustain the objection as to what was contained in the pesticide bottle.
Yes, Your Honor. So moving on, again, what did you learn from this report?
The biggest thing that stuck out to me is that isofenfos tested high as a chemical in the wine bottle, and it also tested high as a chemical when it was in that canister, which is really interesting to me.
Okay, no further questions at this time. We pass the witness.
All right, defense.
Permission to cross?
You may proceed.
Mr. Peraz, you were laid off your previous job, is that right?
Yes, I was, due to budgetary reasons.
And you weren't just laid off, you were in need of a job. Is that right?
Yes, that's correct.
In fact, you weren't just needing a job, but a Kickstarter for your career. Is that right?
Yeah, I wanted to relaunch my journalism career.
So is that a yes to my question?
Yeah.
All right, I'll turn your attention to today's case. You spent over a year investigating just this case. Is that correct?
Yeah, that's an average length of time for an investigation.
Spending much time and energy.
Oh, yeah, of course.
Even going to the extent of going undercover, correct?
Oh, yeah, I have a whole bunch of monikers when I do investigations.
Yes, and you even went into restricted areas. Is that right?
Yes, of course. Most journalists have to go into restricted areas.
Where you weren't given permission at all. Is that correct?
No, that's fairly regular for us journalists.
So is that a yes to my question?
Yes.
You mentioned seeing a bottle of Cara wine on one of your visits. Is that right?
Yes, I did. It was surrounded by a bunch of pesticides.
You mentioned that you saw the same bottle twice. Is that correct?
Yes, that's correct.
But you have no knowledge of it. You have no idea if it was replaced in any way. Is that correct?
I'd only seen one bottle of Cara wine the entire time I was there in the exact same place, surrounded by pesticide. I believe it's the same bottle.
Is that a yes to my question?
It's the same bottle in the same place, yeah.
Moving on. You spent much time at the winery to familiarize yourself with the staff. Is that right?
Of course.
And the people involved with the wedding. Is that right?
Yes.
And you saw Petrillo that night. Is that correct? The night of the rehearsal dinner?
Yes, I did.
And that she appeared to be disoriented.
That's correct.
You had intention with speaking with her. Is that right?
Yes, I'd wanted to talk to her.
But you didn't.
I did not. That's correct.
You decided to interview her on her wedding day. Is that right?
Yeah.
Where she would be most preoccupied.
Yes, that's one of the most important days of her life. I wanted to catch her when she was happiest.
So is that a yes to my question?
Yeah, it's the most important day of her life.
And before you left that night, you were concerned for her health. Is that right?
Yes, a little bit. She seemed fairly woozy on the dance floor.
Yeah, she appeared intoxicated. Is this correct?
Yes.
But you didn't do anything.
I'm sorry, what do you mean?
You didn't do anything. You went home.
Yes, that's correct. I didn't have anything else planned for the night.
I pass this witness.
Any redirect?
No, Your Honor, and we ask the witness to be seated.
All right. Mr. Paris, you're excused.
Thank you.
Plaintiff, call your next witness.
Yes, Your Honor. At this time, the plaintiff calls Mr. Sam Arnold to the stand.
Right.
May we proceed?
You may.
Please introduce yourself to the court.
Yeah, my name is Sam Arnold.
And where are you from, Mr. Arnold?
Well, I'm originally from Memphis, but now I live right here in Midlands.
And what do you do for a living?
Well, originally I had dreams of becoming a celebrity chef. I probably watched too much Gordon Ramsay growing up. But I decided to put those dreams on hold, and now I own my own catering company right here in Midlands, where we serve the best barbecue outside of Memphis itself.
And how are you involved in today's case?
Well, I was hired by Harper Martini back in November of 2018 to cater the wedding of Genesis and Casey at Peony Estates, which is Harper's winery. I had done business with Harper in the past, and when it came time to cater the wedding, she kept me and my business in mind.
So let's talk about what happened once you accepted the job. How did you begin preparing for the wedding?
Well, naturally, the first thing we do is meet with the client to discuss what the menu for the event will be. One time we didn't do this. We ended up with enough smoked ribs for only half of the people, and so much boiled corn we actually had to send people home with doggy bags. It was a memorable mistake, to say the least.
And what can you tell us happened at this meeting for the menu?
Well, it occurred in late November at Peony Estates. When I arrived, Harper was walking back from the vineyard with a bottle of bug-off pesticide. As she got closer, I got out to meet her. We walked into the kitchen to discuss the menu.
You mentioned you headed into the Peony Estates' kitchen. Where was the bottle of pesticide at this point?
Well, I mean, at first I was shocked when she just kind of walked into the kitchen with it. But I mean, I almost fell over of shock when she just carelessly tossed it in the corner of the kitchen.
So what did you do when she threw it in the corner of the kitchen?
Well, I mean, I mentioned to Harper that a kitchen really wasn't the place for a bottle of something like that. It seemed like it finally clicked with her, so she went ahead and threw it over, or moved it.
Where did she move it to?
Quite possibly the next worst place it could be, the bottling area. It reminded me of the phrase
Objection, speculation.
You mind explaining that?
Your Honor, in the witness report, he mentions an employee area, not knowing what this is.
So you're saying the witness
he has no way to know that the witness has no way to know what this room was.
The response, plaintiff?
Yes, Your Honor. The witness is well aware of where the bottle was put, and that's simply what he's testifying to today. He's not speculating on anything. If opposing counsel has issue with the validity in that statement, they can bring it up on cross-examination.
Since the opportunity presents itself now, defense, are you, let me, just to be clear, is your claim that this witness is actually contradicting something they said in their affidavit?
This witness is adding to their affidavit. They are actually saying what the place is instead of not knowing what it is. In the affidavit, the witness does not know what the employee's room is. just mentions that she moved the pesticide to an employee room.
Would you like the opportunity to voir dire the witness to establish this?
If I may,
All right,
may I begin?
go ahead.
Mr. Arnold,
Yes, ma'am.
after you entered the kitchen, were you aware of the pesticides?
Yeah, I saw Harper walk in with him. She had it on her person.
And are you an employee of Paonia Estates?
I am not, but I have done business there in the past.
And are you aware of the layout at Paonia Estates?
Yeah, I would say I am, just through experience there. I've been around enough to know my way around fairly well, I would say.
Have you entered every room in Paonia Estates other than the kitchen?
No, of course not. Not every room, but after talking with a lot of the employees and just kind of asking questions here and there about the layout, you kind of get a general idea of where everything's at.
And do you know what this room in the kitchen has inside?
I'm sorry, are you asking me if I know the contents of the kitchen?
Do you know what the room, the employee's room in the kitchen, what the contents of the employee's room in the kitchen is?
Well, I've never been in the room personally since I'm not an employee, but I had learned through discussions with other employees and even Harper herself that it led to the bottling area. That was the door to get to go to the bottling area.
May we present Exhibit 4?
You may.
Objection, Your Honor, at this point to relevance. May I be heard?
You may.
Your Honor, specifically this voir dire was to call into question whether or not Mr. Arnold was aware what the room was that he was talking about, the bottling area, whether he knew that that was the bottling area. In fact, Exhibit 4 has nothing to do with this testimony. Opposing counsel was attempting to impeach this witness through this voir dire, and Exhibit 4 has nothing to do with said impeachment.
Your Honor, may I respond?
You may.
Your Honor, my opposing counsel's witness has mentioned that they do in fact know the layout of Paonia Estates with my previous question, and Exhibit 4 is a representation of Paonia Estates.
Your Honor, may I be heard?
I'll give the defense a little leeway here, but if you feel that it is going into irrelevant territory, feel free to re-raise.
Yes, Your Honor.
May I present Exhibit 4?
You may.
Mr. Arnold,
Yes,
are
ma'am.
you aware of this map?
Yeah, I've seen it before. I want to say maybe at one of my events, we had actually handed out maps so the attendees would know where they're going, but I want to say I've seen it before.
Is this an actual representation?
Yeah, I would say so. It looks like it.
Is that from your personal opinion, or have you seen this in
Yeah, I
person?
want to say I've seen this map before.
And in the kitchen area?
Yes, I believe that's it right there in the right-hand corner.
Did you know that there was a bottling and dining room and tasting room by the kitchen area?
Yes, I've actually used every area or been in every area except for the bottling area in all my previous events at Peonia Estates.
Now, can you look at this door, to your left, which goes towards the storage barn? Did you know that this was connected to the kitchen?
I'm sorry, but when I look at the map, I see a parking lot in between the two. I don't really see a connection in the map.
Yes. So you do not know if that employee room was actually a hallway towards the storage barn, do you?
Well, actually, I do know because the storage barn is a complete another building. That's what I'm saying. The map, there's a parking lot in between the two.
But the door was not the door was not labeled bottling area, dining room, or tasting room, was it?
No, ma'am. It was just labeled employees only. But like I said, I had a pretty good idea of what it was just from being around so much, I guess.
But you're not sure.
I'm not sure, but I felt pretty confident.
Your Honor, I believe that this witness does not know what the employee's door actually led to, and therefore should not say that it was the bottling area or any other room.
From what I gathered in the testimony, I tend to agree. Plaintiff, if you feel that there's something else that establishes that this area is a bottling area that this witness does know of, and perhaps use the rationally based perception, you may bring that up. But as it is, the witness cannot say for himself that that was the bottling area. So
Yes,
for
Your
now,
Honor.
I'll sustain the objection.
Thank you.
And may we proceed with direct?
You may.
Mr. Arnold, where did Miss Martini move that bottle of pesticide to, as far as you know?
Well, what I believe to be quite possibly the next worst place, what I believed to be the bottling area. It reminded me a lot of the phrase, if you out of the frying pan into the oven, but that's just me.
And were any cleaning measures taken as far as you saw?
No, not really. I never saw him clean the area the pesticides were in, and I never really witnessed Harper using any gloves or washing her hands after handling it.
Your Honor, speculation?
May I respond?
Go ahead.
Your Honor, I asked the witness what he saw taken as far as cleaning measures. He's not speculating as to anything that happened. He's just telling us what he saw himself.
Any response, defense?
Your Honor, the witness mentioned not wearing gloves and not being able to clean the area properly. The witness was only there 2 days at most and was not there consistently, and it does not know the cleaning, how they clean Paonia Estates.
As far as long as his testimony is limited to what he observed, I'm going to overrule that objection. But if you do think he's talking about events that he didn't personally observe or didn't use his rationally based perception, you may object to that. But for now, overruled.
I'm sorry, Mr. Arnold. I'll repeat my question. Did you see any cleaning measures taken at that point?
No, not really. I never witnessed them clean the area the pesticides were in or anywhere around that. And when handling the pesticides, I never saw Harper wash her hands or put on gloves or anything like that. It was honestly kind of disturbing to me.
So what happened after Miss Martini moved the bottle of pesticide?
Well, we went on ahead with our meeting to discuss the menu. And it was at this time I learned that Harper had actually hired a wedding planner. I figured at this point it'd just be more efficient to meet directly with that planner, and so I did.
So what happened after your meeting with the wedding planner?
Well, we went ahead and we decided on a tasting event for the day of February 8th, 2019. It's a great opportunity for both parties involved to go ahead and get a real feel for the menu and decide on what they want for the event.
So let's talk about that tasting event. What happened?
Well, when I arrived for the event, I was rather shocked at the state of the kitchen. It was clean for what felt like the first time in forever. After that, I ran into Harper, who seemed really happy for herself.
And how was your interaction with Miss Martini?
Well, I asked her about the kitchen being so clean, and she said that they were expecting an inspection that day. And suddenly the mystery of the unusually clean kitchen was a big mystery no more.
And what do you mean by that?
Well, in my previous experience at Peony Estates, it's not unusual for the kitchen to be an absolute disaster and almost completely unorganized. But I've also talked with Harper before, and she's told me they have an inside man at the FDA. And it's usually on the inspection days that the kitchen ends up being the clean one I found that day.
And are you familiar with Midland's Buildings Code?
Yeah, of course. As a kitchen owner myself, I have to both know and follow the code in order to stay running, and also to ensure me, my employees, and my customer safety, most importantly. It's just common ethical business practice, really.
So, with that code in mind, what did you think about Peony Estates cleaning up their kitchen right before an inspection?
Well, I mean, of course, it's smart to help out your business in any way you can with any information you have. I mean, that point's not really an argument. But when it comes to something like the cleanliness of your kitchen, I mean, that should be an everyday type of thing to me, especially with the amount of business Peony Estates has.
Now, I want to talk to you about some wine that we've heard about. Now, are you familiar with Cara wine?
Yeah, of course. Me and Harper talked about it quite a bit the day of the rehearsal dinner.
And would you recognize a picture of that bottle of wine if I were to show it to you?
Yeah, I believe so.
Your Honor, permission to display Exhibit 2A onto the screen?
Go ahead.
Mr. Arnold, what can you tell us about this bottle of wine?
Well, I first saw it when I walked into the kitchen on the day of the rehearsal dinner. Harper was in the kitchen, and she was working with some other more common bottles of wine I'd seen before. But the Cara wine, this one in the picture, is one I'd never really seen before.
And so what did Miss Martini have to say about this bottle of wine?
Well, when I asked her about it, she said it was a one-of-a-kind special that Peony Estates had created. And it kind of reminded me of my special redneck pulled pork recipe, which was a fiasco. But yeah, it really alarmed me, though, because she said she'd been keeping it in the bottling area.
Well, why did that alarm you?
Well, because that was the same area I believed she put the pesticides just a few months earlier. Pesticides and wine are a combination this guy wants no part of.
Thank you, Miss Solis. We can remove the wine bottle from the screen. And so what happened after she told you that the wine bottle had been in the bottling area?
Well, she asked me if I would do the honor of presenting it to Genesis like a wedding gift at the wedding, which of course, or the rehearsal dinner, excuse me, which of course I accepted. I mean, where I come from, that's a huge honor.
So what did you do after that?
Well, as I was leaving the kitchen, I observed another bottle of pesticides just sitting out openly on the counter of the kitchen. I'm a big believer in the phrase, if you're playing with fire, you're begging to get burned. But I mean, I don't know. Maybe it's just a Memphis thing.
And were any cleaning measures taken as far as you saw at this point?
Once again, not really, not at all. I never really saw them clean the area the pesticides were sitting in. I don't recall anybody washing their hands before handling it or after handling it. And I don't recall anybody wearing gloves being around it, which is kind of surprising from our line of work.
You mentioned how you were going to give the bottle of wine to Miss Petrillo. What can you tell us about that?
Yeah, at the rehearsal dinner, Harper stood up to give a speech, and that was my cue. As she started to wrap up, I went ahead and I presented the bottle to Genesis like I'd been asked. And it was around that time I decided it was time to start packing up. So I headed home about 10:15. It had been a long day.
What, if anything, do you know happened after you gave that bottle of wine to Miss Petrillo?
Well, I mean, only the obvious. Genesis had passed away that next day and the wedding was canceled.
How did you respond to this news?
Well, of course, it's sad anytime there's a loss of life. And as a businessman, I was terrified that it might have been a result of my food. But nobody else from the event got sick after eating it that night. So it provided me with a little bit of comfort in knowing that I wasn't responsible. I just really hope and pray it wasn't that wine.
Thank you, Your Honor. Pass the witness.
Right. Defense.
Hello, Mr. Arnold. I'm gonna ask you a few questions.
Yes, ma'am.
You consider yourself a food service provider, correct?
I would say that's a pretty accurate description, yeah.
And you owe a lot of your business exposure to Harper Martini.
Yeah, Harper and Peony Estates has been great. They really helped kickstart my business, and they've been a steady source for business for me for a while now.
You have certain standards when it comes to kitchen organization, correct?
Yeah, that's something I really learned in my training in Paris. Tip-top shape, tip-top organization. I believe if you start with a solid foundation like that, it really helps your business grow.
Which is why you usually prefer to prepare food at home in your own kitchen.
Yeah, it's just, I guess, kind of a personal thing. I know my standards and I keep them high when I'm at my place of business. So it's usually just a lot better for me business-wise to prepare at my own place.
Now let's talk about the first time you entered Peony State's kitchen. You noticed that Harper had dropped pesticides in the corner, correct?
Yeah, we walked in together. I was actually right behind her as we walked into the kitchen.
And you told Harper that this was a violation, correct?
Yeah, I mean, it surprised me, so I said something. I tried to be nice about it, though.
But she didn't argue, right?
No, which, I mean, I chalked it up. Hey, maybe just a mistake. But it kind of clicked with her once I said something.
And she took them out immediately.
Yeah, she walked over and grabbed them to move it.
Now let's talk about the tasting event on February 8th. When you arrived to the kitchen, it was clean, correct?
Yeah, spotless. It almost looked as good as mine.
And it met all your standards, right?
Yeah, that one particular day, yeah.
And you were able to cook and feel comfortable, correct?
Well, not that day. I just walked into the kitchen to see what all the commotion was about.
But you were able to show off your plates and you weren't worried about them, correct?
Well, that particular day, I didn't use the kitchen, I don't believe. I just walked in to see where Harper was and see what all the commotion in the kitchen was about.
On February 8th, on the testing event, you showed off your plates to Blair and Genesis, Casey, and Harper, correct?
In the dining area during the tasting event, I showed him some of the options we had as far as plating, yes.
And you were aware that these plates were safe to your concern, to your ability.
Well, yeah, the plates came from my kitchen. I believe I brought them over as one of the options we had for the event.
I pass the witness, Your Honor.
No redirect, Your Honor. I just ask that the witness be excused.
Right. Mr. Arnold, you are excused.
Thank you, Your Honor.
Plaintiff, call your next witness.
The plaintiff now calls Inspector O'Keefe to the stand.
Right.
Your Honor, I'd also like to check that you can hear me okay.
Yes.
Can you hear me as well, Your Honor?
Yes, I can.
Thank you.
Please introduce yourself to the court.
Hello, I'm Federal Inspector Riley Adkins O'Keefe. I know that's a bit of a mouthful, so y'all can just call me Inspector O'Keefe.
What do you do for a living?
Well, currently I'm a senior health inspector for the Food and Drug Administration, working under the Rapid River Valley Department of Health and Environmental Safety, where I've been working since 2013.
What is your educational background?
Well, first I got my bachelor's in 2010, and then I went on to get my master's degree in viticulture and enology from Midlands University in 2012.
Can you explain what viticulture and enology is for the jury?
Sure. Viticulture is the science and study of grape and grapevine cultivation, and enology is simply the study of wines and winemaking. I'm passionate about both. And because of my experience in these areas, I'm usually assigned to any FDA cases involving wineries or vineyards.
Were you ever assigned to inspect Peony Estates?
I was assigned to inspect Peony Estates on multiple different occasions, with my most recent inspection taking place on May 8th of 2019.
And why were you sent there?
Well, Peony Estates is located right next to Salo Swamp and therefore has a high capacity for pest problems. So it's my job to go out to the property and make sure they're following the health and safety laws that are outlined by the Midlands Building Code, especially concerning the control of pests and the storage of pesticides.
Well, Inspector O'Keefe, how do you normally conduct these inspections?
Whenever I conduct an inspection at Peony Estates or any other winery for that matter, I use what we call in the field the bucket list method.
And what is the bucket list method?
Well, it's my job to make sure that the business I'm inspecting follows all the health and safety laws outlined in the Midlands Building Code. So the first thing I do is pull up the code, and during my inspection, treat that code like a bucket list. So the first thing I want to make sure that every single thing on that bucket list is checked off. And if a business simply can't check off even one of those items on the bucket list, then they failed the inspection because they violated the Midlands Building Code.
Is this method standard in your field?
Absolutely. This method is the most reliable and efficient way to conduct an inspection. I don't know a single inspector that doesn't use it.
And how did you use this method during your last inspection at Peony Estates?
Well, for my inspection on May 8th, the code I was using for my bucket list was Midlands Building Code section 12-100. I then visited the property and toured its facilities, using a map to take notes. I also spoke to employees while on this tour in order to check off the items on my buildings code bucket list.
And what is Midlands Building Code section 12-100?
Well, the code specifically outlines how businesses like Peony Estates are to manage pests in their facilities and how they are to use and store pesticides in order to avoid contaminating any of their products.
Did Peony Estates meet all the requirements of that code?
No, they didn't. On my most recent inspection, I found 4 major violations of this code. And while one is enough to violate the code, not being able to check off 4 items on my bucket list is extremely concerning to me.
Why is that concerning?
Well, the Midlands Building Code is in place for a reason. Failing to meet the requirements outlined in this code could result in the contamination of the wine or with pesticides. And that could cause any patrons of Peony Estates to get extremely sick or even to die.
Inspector O'Keefe, let's talk about those violations. Could you possibly explain them in more detail for the jury?
Sure, absolutely. In fact, I actually brought along the map that I used to take notes so the jury can see what I saw the day of my inspection.
Your Honor, permission to display this demonstrative that opposing counsel has already seen.
Okay.
Inspector O'Keefe, what does this demonstrative show?
Well, as I mentioned, this is the map that I used to take notes during my most recent inspection of Peony Estates. I made note of 4 violations in particular while I was in the bottling area of the winery.
What was the first violation?
Right. So first and foremost, there were 3 open canisters of pesticide in the corner of the bottling area, which I've labeled here as number 1. Well, further, there was a bottle of wine called Cara sitting by itself on a shelf right next to those containers of pesticide, leaving a high likelihood of the wine being contaminated.
And what was the second violation?
Right. So the second violation I found while I was talking to all of those employees at Peony Estates, which I've labeled as number 2. I found that these employees had no training on how to handle the storage of the pesticides properly.
What was the third violation at Peony Estates?
Right. The third violation I noted was the drainage system in the bottling area that was blocked up by dirt and other debris, which I marked here as number 3.
And finally, what was the fourth violation at Peony Estates?
The final violation, which I've marked here as number 4, is the improper storage of pesticide, as I found it in the bottling area of Peony Estates.
So how did all of these violations compare to parts of the code?
Right. So I have a chart here to help make these comparisons a little more clear. According to the code, businesses have to handle and store pesticides in a manner that prevents food or beverage contamination, and they have to keep any equipment or areas used to make food clean at all time. By having pesticides in the bottling area, they are not properly handling or storing them, and if the employees aren't trained on how to do so, then they won't ever be. Further, a blocked drain means that Peony Estates cannot properly clean their bottling area, which is another violation of the code.
Your Honor, permission for Inspector O'Keefe to take down his demonstrative.
All right.
So what did you do in response to these violations?
Yeah, so in response to these violations, I allowed Peony Estates to remain open on a probationary status. I told them that I would be back within 45 days to conduct another inspection to ensure that they'd fixed all of these violations.
Why was it so important that they fix these violations?
Well, once again, the Midlands Building Code is in place to protect consumers from their food or beverages being contaminated, specifically with pesticide. If these violations weren't fixed and someone were to eat or drink something that was contaminated, well, it could make them extremely sick and could even kill them.
No further questions, Your Honor.
Right, defense?
Yes. Mr. O'Keefe, you conducted 3 health and safety inspections at Peony Estates from the time span of November 5th, 2015 to May 8th, 2019, correct?
That's correct.
Right, so now let's talk about that first inspection. That day you inspected the vineyard, correct?
I did.
In addition to that, you inspected the production facilities,
That is correct.
the storage spaces,
Yes,
and the bottling area, correct?
that's right.
And it was clear that there were no violations.
Objection, Your Honor. Relevance, if I may be heard.
Go ahead.
Opposing counsel is referring to a inspection that occurred almost 4 years ago, which is not relevant to the case at hand today. The most recent inspection that Mr. O'Keefe had is the most relevant inspection to today's case because it is what would affect the negligence that occurred at Peony Estates and thus this case at hand.
May I respond, Your Honor? All inspections that Mr. O'Keefe conducted for Peony Estates are relevant because because plaintiff is claiming that Peony Estates violated a health statute.
Your Honor, if I may respond.
Just to be clear, defense, why are you saying that these prior inspections are relevant to the case at bar?
Because inspections can display that there may be a pattern of following certain practices.
Your Honor, if I may be heard on those grounds.
You may.
If defense is attempting to use this to show propensity, then it is improper character evidence of Peony Estates. We cannot use their prior investigations to prove that they are currently adhering to those safety standards. So that would be improper character evidence of Peony Estates.
All right, response?
Your Honor, can I direct you to a case law, Olive and Farrell? Should be under the character evidence section on page 5, I believe. It says that acts and practices can still be considered part of the case at hand if said acts and practices occurred years prior, so long as the acts and practices can be plausibly connected to the case at hand. Mr. O'Keefe has visited Peony Estates on several occasions. Each time he tells Peony Estates that he's going to come back to recheck the same areas that he told them to fix.
Your Honor, if I may respond and make an offer of proof.
Go ahead.
This specific case law in the example goes on to explain that this liability and this character evidence has to do with products that are specifically being produced in that time period. However, it is an offer of proof is that the wine at Peony Estates is produced yearly. So any inspections that occurred prior to 2018 do not have anything to do with the wine that was produced in 2019, which is what we are here to discuss today. And Debel versus O'Falson case law is in regards to different things that happened that affected the product we're talking about today, and none of the inspections that happened prior to 2018 affected 2019 Cara wine.
Your Honor, if I may respond.
Go ahead.
Plaintiff is here claiming that Peony Estates has violated a health statute in regards to the storage of pesticides. And it has been previously stated that Peony Estates has used chemical pesticides prior to 2018, therefore making this relevant to today's case.
I tend to agree. I think Dybel does apply in this case, so I'm going to overrule the objection.
No, Mr. O'Key, it was clear that there were no violations in your first inspections, right?
Yeah, there were no express violations, but their storage shed was a bit too close, which worried me.
Right. But you found that Peonia Estates wasn't using an above average amount of pesticides, right?
No, it was an acceptable level of pesticides at the time.
And then you found that that pesticide was being stored far away enough from the kitchen, right?
I believe at the time I actually thought that the storage shed was a bit too close to the facilities where the wine was stored, and as a result, I was a bit worried that the workers might bring the pesticides into that facility.
Right, but it was far enough from the kitchen for it not to be a safety violation, correct?
Oh, it wasn't a safety violation, but it was definitely a concern of mine that I voiced to the owner of Peonia Estates.
Now let's move on to your second inspection, which took place in July 12th, 2018. You began your inspection where the issue was claimed to be the wine cellar, right?
Yes.
And upon arriving at the wine cellar, you asked Harper Martini about how Peonia Estates deals with cellar pests, right?
Yeah, I did ask that.
And he gives you a clear answer, correct?
He did give me a clear answer, but it kind of seemed strange to me. He was a bit nervous and shifty at the time.
Okay, but you noticed that that these pests that you found throughout your inspection in the cellar were a potential hazard, correct?
Yeah, they were definitely a potential hazard for the consumers of Peonia Estates wine.
But despite your concern, you also informed that the pest itself didn't violate any health statutes, right?
At the time, that wasn't a violation, no.
Right, and you also took some samples of wine from the wine cellar, correct?
I did. In fact, I took 20.
Yes, and you found that all the samples you collected had an acceptable level of contaminant, correct?
Yeah, that's true. At the time, that was the case. But again, these were all prior to my final investigation.
Right, we'll get to that next. And so on your third inspection, you start out at the wine cellar, same as the third inspection, the second inspection, correct?
Yeah, as I mentioned, I go through this bucket list piece by piece, so I consistently use the same order.
And you found that there were no violations in that area, right?
I believe I actually did find some violations.
In the wine cellar?
I'm sorry, not in the wine cellar. My apologies. That was the bottling facility. No.
Right, so there's no violations in the wine cellar.
Not expressly, no.
And there's no violations in the vineyards, right?
Not within the vineyards, no. But again, there were multiple violations around Peonia Estates facilities, 4 in fact, which is more than enough to be an issue.
Right, but despite these health hazards, Peonia Estates was still able to produce wine, correct?
Yeah, they were able to produce wine, but I'm not sure if it was wine people would want to drink.
But that's a yes to my question.
Yeah, that's
right?
A yes to your question.
Peonia Estates was still able to bottle wine, correct?
Again, yes, but not safe wine.
But that's a yes to my answer. They were still able to bottle wine.
They were able to do so.
And they were still able to sell wine, correct?
Your Honor, the defense is out of time for their cross.
I'll let the witness answer that last question.
Yes, Your Honor.
Sorry, could you repeat your question again?
Yes, Peonia Estates was still able to sell wine, correct?
Yeah, once again, they were able to sell wine, but I don't think it was safe wine because of those violations.
I passed the witness, Your Honor.
Redirect?
No, Your Honor, I just asked that the witness be excused.
All right. Thank you. Inspector O'Keefe, you're excused.
Thank you.
All right. I see that we have roughly, before anything else, plaintiff, do you have anything further?
No, Your Honor, the plaintiff rests our case in chief.
Okay. I see we have roughly about an hour and 10 minutes or 13 minutes. Why don't we take a 3-minute break, reconvene at 11:40 a.m. Central Time?
Wonderful.
All right, are both teams back?
Yes, Your Honor, the plaintiff is ready to proceed.
And
Defense is
are
ready to
my,
proceed.
thank you. Are my co-judges back as well?
Yes, sir.
Yes, Your Honor.
Sorry, my co-judges.
Sorry, I thought you said closers.
I might have, I'm not sure. Sorry. Chandler, you also there?
Yes, I'm here.
Okay. All right, seems like we're all back. Defense, you may proceed with your case in chief.
Defense calls Austin Lewis to the stand.
All right.
Please state your name for the court.
Yes, my name is Austin Lewis.
And Miss Lewis, where do you work?
I work at Peony Estates here in Midlands.
Have you always worked there?
Yeah, ever since it opened, which was back in 2015.
Did you have any prior work experience?
Yeah, absolutely. I used to work at Rosie and Pedro's winery. It was owned by Danny Francasio before I moved to Peony Estates.
And how did you end up working for Peony Estates?
Well, I met Harper because she was working at Rosie and Pedro's too. And she came up to me one day back in January 2015. She's like, hey, I'm about to open up my own winery. You want to work there? She offered me a raise and position of head winemaker. I was like, absolutely, I want to work there.
And you mentioned that you were a head winemaker. Could you tell me about what that consists of?
Sure. So I oversee the harvesting, the fermentation, the bottling, anything to do with wine, I oversee that.
And are you aware with any issues Peony Estates was having?
Sure. So Peony Estates bordered a swamp. And because of that, we had lots of roaches, mites, anything that eats grapes, really.
And for these issues, what solutions did you provide?
Well, initially, we got to deal with these pests. So we used to use organic pesticides, but then 2016 and later in 2018, we switched to completely using chemical pesticides, a band called Bug Off.
And what other solutions did you offer?
Back in 2016, Harper wanted to switch, but I was like, no, we got to keep our branding as an organic winery, but Harper just insisted on using chemicals.
Did you provide the employees with any solutions?
Objection, Your Honor, leading.
Nah, I'll overrule.
I'll repeat my question. Did you offer the employees with any solutions?
Well, with the switch to new pesticides, I definitely gave them a new training manual because chemical pesticides are harsher. So I provided them with a annual manual training for them to follow.
You gave them an annual training manual. Could you tell us what this consists of?
Sure. So some of the things was the employees were required to completely change their clothes after dealing with pesticides just to prevent any cross-contamination from happening. They're also required to wash hands anytime they even dealt with pesticides, even if it was simply moving it from one location to another.
And how did you notify your employees about this switch?
Through email. That's our primary form of communication between all the employees.
Your Honor, permission to display what's been pre-admitted as Exhibit 12.
Oh, go ahead.
Ms. Lewis, is this an accurate representation of your email?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
Ms. Lewis, why did you write this email?
Well, like I said earlier, it's our primary form of communication, and I wanted to just inform all the employees of our new practice and that we're switching to a chemical pesticide.
And what precautions did you take moving on, what precautions did you take while spraying down the winery?
Well, we followed all the industry standards. Anything that was bolted down, we covered with a plastic tarp so they didn't get pesticides on it. Anything that could easily be moved, we moved out of the room. And then we waited 48 hours after spraying to move everything back in.
No further questions, Your Honor. I pass this witness.
Right. Plaintiff?
Yes, Your Honor. Good morning, Ms. Lewis. I'd like to begin with your history with Peony Estates and Mrs. Martini. You first met her while working at Rosie and Pedro's winery, correct?
Yes, that's correct.
And at the time, around 2015, she introduced the idea of Peony Estates.
Yes, that is true.
And when she asked you about Peony Estates, she offered you a promotion to move to her winery, right?
Yes, that's correct.
And that promotion also came with a big raise in your salary?
A 10% increase in my salary, yes.
Now, you ended up with a 10% stake in Peony Estates as well, correct?
Yes, that is true.
So you partly own the winery.
Small portion, but yeah.
And if they are found liable today, you will lose that 10% stake, won't you, Mrs. Lewis?
Yes, that is true.
So let's move on and discuss the chemical pesticide usage at Peony Estates. You began using these chemical pesticides outside of the winery and inside the winery around 2018?
Yes, we switched to inside in 2018.
But you don't personally condone the use of these chemical pesticides, right?
No, I do not.
Your Honor, relevance.
Your Honor, if I may respond.
Go ahead.
The case we are talking about today is negligence, and the usage of this chemical pesticide, especially the dangers of this chemical pesticide, are relevant in today's case, especially with a Peony Estates employee and how they're dealing and handling with those chemical pesticides.
Response, Your Honor.
Sorry, plaintiff, were you done with your?
Yes, Your Honor, that's fine.
Okay. Defense, what's your response?
Your Honor, how does an employee's preference on pesticide uses have to do with a negligence per se case?
I think it's very irrelevant since you're asking me. So I'm going to overrule the objection.
Now, Mrs. Lewis, you do not personally condone the use of these chemical pesticides, correct?
Yeah, that's true. I was against it.
In fact, you advocated really strongly against Mrs. Martini because you believed they were so dangerous.
Yeah, but at the end of the day, you got to follow what the boss says.
So let's move on to why those pesticides are dangerous. Peony Estates is located on a slope, correct?
Yes, that's correct.
And because they're located on a slope, these chemical pesticides tend to get trapped in certain parts of the grapes, right?
Yeah, so runoff kind of leads it to gathering at the bottom of the slope.
So there are some grapes that have higher concentrations of this chemical pesticide.
Yeah.
And every year you discard of those grapes that are dangerous, correct?
Yeah, I even roped them off so employees would know not to harvest those grapes.
But in 2018 you were gone, right, Mrs. Lewis?
Yes, sadly for a family emergency.
So you were not there when the harvesting period happened in 2018?
That is true.
And the only person you asked to handle these grapes was Mrs. Martini?
Yeah, that's correct.
She personally doesn't even want to throw away these grapes, right?
No, she didn't, but as a head winemaker, she kind of followed my lead on that.
But Mrs. Lewis, you never heard of these grapes being properly taken care of, did you?
No, I trusted Harper Martini to follow my advice.
You never even checked up to make sure these dangerous grapes were discarded of, did you?
I didn't, but I mean, I could kind of tell from the total harvest altogether that nothing seemed out of the ordinary and those were added.
So that is a no. You were never aware that these grapes were properly discarded of?
I couldn't say for certain. No, I could not.
And Mrs. Lewis, the wine that is produced at Peony is produced yearly, correct?
Yes, that's correct.
So this 2018 batch of grapes would have made Peony Estates 2019 wine?
Yeah.
Let's move on to some of the health code violations at Peony Estates. Now, they were cited in May of 2019 for improperly storing chemical pesticides.
Yes, in 2019.
And specifically, these chemical pesticides were too close to the production of wine.
Yes, that's correct.
Now, you wanted to take time to retrain your employees because of this mishandling.
I did, yes.
But Mrs. Martini wouldn't allow you to.
Yeah, that is true.
So the only thing that occurred after you failed an inspection was you putting up a few signs around Peony Estates?
Yes, that is correct.
And Mrs. Lewis, you did not believe that was anywhere near sufficient enough to fix the violations at Peony Estates, did you?
No, I did not. But I increased my vigilance in it, and I advised the employees to do the same, but I couldn't do anything other than put up some signs.
So again, you do not believe Peony Estates did enough to fix these violations?
Personally, no, but
No
gotta
further
follow the
questions, Your Honor.
process lead.
Any redirect?
No, Your Honor. I just ask if my witness can step down.
All right. Thank you, Ms. Lewis. You are excused. Defense, call your next witness.
Yes, at this time, the defense calls Mr. Danny Francasio to the stand. Mr. Francasio, are you here?
Yes.
Okay, I see you now.
Can you hear me? Can you see me?
Yes. Yes.
Okay. Bueno.
Can you please state your name?
Mi nombre es Danny Francasio.
Mr. Francasio, what do you do for a living?
Well, I make wine for a living. Specifically in my winery, Rosie and Pedro, here in Rapid River Valley.
How long have you been in the winery business?
Oh, I've been about here for 15 years after the previous owner, Paul, sold it to me.
Can you please tell us what it takes to run a I'm sorry. Can you please tell us what it takes to run a winery?
Well, it takes a lot to run a winery. We harvest, stem, press, and pour the grapes into steel tanks in our warehouse. And that's where the magic begins. And by magic, I mean the fermentation. During the aging process, we regularly test and monitor these wines for compositions for unwanted contaminants. My winery did not just become successful overnight.
When did you first meet Harper Martini?
I met her way back about 2012.
And what was Harper's job in your winery?
Originally, I hired her as a cellar hand. She's just, responsible for pouring the grapes into our fermentation tanks and transferring that fermented wine into our cellar barrels. She also monitored the wine's climate, and made sure that it was always pest-free. I eventually promoted her.
While Harper Martini worked under you, did your winery use any pesticides?
Yes, we used it about 5-6 times, just a handful.
When did Harper decide to leave Rosie and Pedro's?
Oh, I remember that day. She decided to leave January 2015. She came into my office and she notified me of her plan. That she took my employees and customers with her. I can't say I was happy, but I really thought she was family.
Did you ever have contact with Miss Martini after she left?
Yes, she did contact me after she left, unfortunately.
Was this the only time?
No, she contacted me more than I would have liked, if I'm being honest here.
No, why did Harper Martini contact you?
She was seeking advice for her pest control problem. I didn't answer the first time because pinche cabrona, but she emailed me again and again. And me being a nice person, I answered.
Would you recognize a copy of this email if I were to show it to you?
Yes.
Your Honor, may I display what has been pre-marked as Exhibit 14 on the screen for all to view?
You may.
Mr. Francasio, what is this you're seeing on the screen?
I believe that's an email from Harper Martini to me.
Is this a fair and accurate copy of this exhibit?
Yes, I believe so.
And do you believe this will be helpful in supporting your testimony here today?
See.
Your Honor, at this time, defense is offering to enter Exhibit 14 into evidence.
Any objections?
No, Your Honor.
All right, it is admitted.
Now, Mr. Francasio, what advice did you give Harper Martini?
Well, basically, to be careful using that pesticide. Remove all wine from area using pesticide in the wine cellar.
Can you tell us why you decided to help her out?
Look, business did go down after she left, and I did blame Peony Estates for that for a while. But if I had an answer, somebody could have ended up getting hurt. And I don't know if I could forgive myself if that happened.
When was the next time Harper contacted you?
I believe 2018, she emailed me to actually apologize for Casey and Genesis venue change.
Did she ever seek any more advice in regards to pests?
See, otra vez, another time in May 2019, she emailed me, notifying me that she had a health inspection that did not go too well. And with a wedding just a few weeks away, she really needed my help. So once again, for everybody's sake, and of course Casey, I decided to help her out.
Now I want to talk about your association with Lonnie Parras. When did you first contact Mr. Parras?
Lonnie Parras, I believe about late 2016, I want to say.
Why did you contact Mr. Parras?
Well, I was concerned with Ms. Martini exposing the wine to potentially deadly chemicals, so I decided to contact Lonnie and see to let him know about it.
Did you ever hear back from him?
No, so I assumed Peony Estates was up to code. Everything should have been okay.
Your Honor, at this time, the defense passes the witness.
All right, plaintiff.
You own Rosie and Pedro, right?
See.
And you met Mr. Martini while he was working for you.
Excuse me, I could not hear you.
And you met Mr. Martini while he was working for you.
Yes.
And it's true that you accredited Mr. Martini for putting Rosie and Pedro on the map.
Excuse me?
And it is true that you accredited Mr. Martini for putting Rosie and Pedro on the map, correct?
Not entirely, but she did add some very creative and innovative ideas that added us to the more like wedding and ceremonial area.
So directing you back to my question, you did accredit Mr. Martini for putting Rosie and Pedro on the map?
If you ask me, my wine put me on the map.
Okay, so moving on. Because of this, you were proud to have Mr. Martini represent your company, right?
Yes, she was family. I loved her. I promoted her. I thought she was everything.
However, Mr. Martini decided to quit, right?
Unfortunately so, like I mentioned earlier, she did.
And took half your employees, right?
Yeah, she did.
And you felt betrayed?
I felt so betrayed.
In fact, you were so mad when he told you he was quitting and taking half your employees.
Objection, hearsay.
May I have a response?
What was the question again?
I didn't finish asking the question. It was, in fact, you were so mad that when he told you he was quitting and taking half your employees, you scribbled his last check.
Defense, do you mind explaining why you think this is hearsay?
Yes, opposing counsel is going into what Mr. Francasio told Ms. Martini, which is an out-of-court statement being taken for the truth of the matter.
I don't believe that's where the question was going, but if that is where he's going, then feel free to re-raise the objection. But for now, I'm going to overrule.
Yes, Your Honor.
I'll re-ask the question. In fact, you were so mad when he told you he was quitting and taking half your employees. You decided to scribble his last check, right?
I'm sorry, you say he? Who you mean by he?
Martini.
You mean Senorita Martini?
Yes.
Oh, okay. With that, well, I remember seeing a lot of red that day, but yes, I did things I was not proud of.
And then you threw it at Mr. Martini.
I believe so.
And then you banned him from the property.
Who's him?
Martini.
Senorita Martini?
Yes.
Yes. So I was like, get out of here.
After Miss Martini quit, she opened her own winery called Peony Estates, correct?
Yes.
And in 2016, Mr. Martini emailed you asking for help with the pest problem in the winery cellar, correct?
Just like I said earlier, she did.
Okay. In this email, he stated that he wasn't sure how to best handle the problem with pesticide, correct?
Again, I think you mean Senorita Martini?
Yes.
Yes.
In fact, you gave Martini advice only because you were concerned that Peony might be involved in unsafe practices.
Not just that, but I like to believe that I am a good person. So I'll do what I think is best.
But you did give her advice because you were concerned that there was unsafe practices, correct?
That as well. Not only that, but yes, that too.
Okay. You were concerned that his consumers might be poisoned by pesticide, correct?
Objection, speculation.
The witness can testify whether he was concerned. I'm going to overrule.
You were concerned that his consumers might be poisoned by pesticide, correct?
That was a possibility. I was concerned not to play out all the scenarios.
You were so concerned that you contacted a well-known investigative reporter in 2016, correct?
Yes, you mean Lonnie Paras? Yes.
Yes. And then in May of 2019, you received another email from Martini.
Yes.
Asking for advice because Peony Estates failed a health inspection, correct?
She interpreted, yes.
In the email, she was asking for advice on pest control.
Otra vez, yes.
And in this email, she mentioned that the pesticide were stored in the bottling area, right?
Correct.
So 3 years after you originally gave Martini advice, she was still asking for your help, correct?
She asked me for a long period of time and way too much, I will say so.
So yes.
Yes.
Now, I want to direct your attention to Peony Estates' impact on your company. The opening of Peony Estates in 2014 harmed your business, correct?
Yes, it did.
And you also stated that business would improve if the investigator found anything damning in Peony Estates, correct?
Well, I don't control the market. I can only speculate at best, maybe guess.
So is that a yes to my question?
Excuse me?
Is that a yes to my question?
I don't know. The market's unpredictable.
Okay, moving on. Okay, so to clarify, you believe that Peony Estates is doing a poor job of handling the pesticide issue, right?
Objection, speculation.
May I have a response, Your Honor?
You may.
I'm not asking him to speculate. I'm just asking him to state what he believes based on the things he's seen from Harper Martini.
As I tend to agree, as long as this is kept within the scope of the witness's own personal opinion, I'll allow it. So
Yes, Your Honor.
overruled.
So you believe that Peony Estates is doing a poor job handling their pesticide issue, right?
Listen, me and Martini may not get along very well, but after I sent Lonnie Paras and never heard anything back, I just assumed everything was up to code.
Up to code. Okay. And then one last question. So you don't believe there was a pesticide issue, yet you sent Lonnie Paras to investigate, correct?
I only had a guess. So I said, hey, just in case, if there is, take a look.
So you were concerned. So you were concerned enough to send Lonnie Paras to investigate?
Concerned enough that initially, yes.
Okay. Yes, no further questions at this time, Your Honor.
Gracias.
Any redirect?
A brief redirect, Your Honor.
Okay.
Mr. Francasio, can you tell us why you didn't hear back from Mr. Lonnie Paras?
I couldn't say for certain. It's been so long, so I just kind of assumed everything was up to code. Maybe he got busy with other work. I don't know.
No further questions, Your Honor. This time I pass the witness.
Before we do that, is there any recross by the plaintiff?
No, Your Honor.
Okay. In that case, Mr. Francasio, you are excused.
Gracias.
All right, defense, call your next witness.
The defense would like to call Ryan Cannon. Good afternoon, Mr. Cannon. Can you please state your name for the court?
Yes, my name is Dr. Ryan Cannon.
And Dr. Cannon, can you please tell us what is your educational background?
Absolutely. So I received my bachelor's in science in chemistry from the Ohio State University, go Buckeyes, and my MD with an emphasis in toxicology from Harvard Medical School.
And after graduating from Harvard Medical School, what did you do?
After graduating I used to be the chief toxicologist at Massachusetts General Hospital in Boston. And following my time there, I took on a faculty position at Midlands Medical School.
And where do you work at now?
I am an associate at Gardner Consulting Incorporated, based in Beverly Hills, California.
Can you tell us a bit more about your consulting work?
Absolutely. So I work with cases that involve my area of expertise, which is toxicology and pharmacology. And if need be, I testify either in person or through declaration.
And can you tell us your relationship with Tetski's CEO?
Absolutely. They are a huge client of Gardening Consultants. That is, it's a pesticide company as well. And although I definitely wouldn't want to lose them as a client. The conclusions in this report are well supported by facts and evidence and are not affected by that relationship.
I would like to turn your attention to the details of this case. Who contacted you to participate?
Yeah, I was hired by Harper Martini and Peonia Estates on April 2nd.
And were you paid for your services here today?
Yes, but this work is very time consuming. I charged a flat rate of $50,000 for my consulting fees. People typically get paid the same amount when reviewing other doctors' work. And it's just simply because the work is so time consuming.
And can you tell us how you prepared for today's case?
Absolutely. I reviewed the works of Dr. Kwan, as well as multiple exhibits and the affidavit of Angel Rodriguez.
And were you able to examine the body of Genesis?
I'm sorry. I was not. I was hired after Genesis was cremated.
And you mentioned not seeing the body. Is this type of practice widely accepted?
Yes, it is in the medical world, and we all do work. We have to work in hypothetical scenarios. So yes.
And what methods did you use to come up with your conclusions today?
A review analysis, also known as RAC.
Did you receive? Did you apply these to today's case?
Yes, absolutely.
And can you tell us what conclusions you arrived at?
Yes, I came up with 4 potential conclusions. The first being alcohol poisoning.
Objection, Your Honor, under Rule 702 to a lack of foundation.
Do you mind elaborating which part of 702 they failed to meet?
Yes, Your Honor. Specifically, I'm objecting under Rule 702C with regard to the methods of this witness. Your Honor, if I could direct your attention to a piece of case law in the case law packet on page 3. The case law is Tarot Readers Association versus Merrill Dow. Your Honor, it was determined in this case that under Rule 702C, judges should consider whether the theory or technique has been or can be tested, where it's been subjected to peer review and publication, whether it has a known error rate, and whether it has gained widespread acceptance within the field. We've yet to hear any of that information from Dr. Cannon, and until they do so, they cannot go into his conclusions for today's case.
Permission to respond?
Please.
Your Honor, my witness provided the methods he used as RAC, which is review, analyze, and conclude. And this is typically used amongst the community to come up with conclusions.
Your Honor, May I respond?
Go ahead.
Your Honor, my response is twofold. First, we haven't heard any of that testimony from this witness. He did say that he used a method called RAC, but didn't go into detail as to what each one of those standed for this acronym. Furthermore, my objection is specifically regarding the case law in today's Tarot Readers versus Merrill Dow, in which they have not laid the foundation for the judge in today's case to reliably find validity in this method, because we have yet to hear whether it can be tested, whether it was subject to peer review, or if it has a known error rate.
Defense, what's your response to opposing counsel's use of tarot readers?
Your Honor, Tarot Readers states that 702C is a testimony reliable of products of the principles and methods. My witness mentioned RAC, which is review, analyze, and conclude. He only had records to analyze and was not able to actually test the body. So there is nothing that he could have used other than review, analyze, and conclude.
Specifically, what's your response to opposing counsel's claim that you haven't laid any foundation that there was peer review, publication, known error rate, or widespread acceptance?
Your Honor, not because something is peer reviewed means that it is accepted amongst the community. However, RAC is accepted amongst the community and it's used in the field that Dr. Cannon is in today. He also mentioned that he is a toxicologist and pharmacologist, which is the foundation for what he will speak about.
Let's make sure that we're narrowing the issue here. It's not about whether or not he has the proper training. It's whether the method he used was reliable under 702C. You're saying that that you've established that this method has gained widespread acceptance. Is that right?
Yes.
Plaintiff, do you have a response to that?
Yes, Your Honor. While opposing counsel might be saying that, we've yet to hear that from the witness, and we also haven't heard from the witness about the known error rate, publication, or peer review. We have to hear those from the witness, not from the attorney during an objection battle.
Your Honor, may I re-ask the question?
Go ahead, but for now it'll be sustained.
What methods did you use to come up with your conclusions?
Yes, so I use the review, analyze, and conclude method known as RAC, which is typically used amongst the community. And review, you review the facts of the case and then deeply analyze it, and then base your conclusions off of that, what you have reviewed and analyzed.
Now, can you tell us what conclusions you came up with?
Again, Your Honor, I'm going to re-raise my objection under Rule 702C to a lack of foundation.
Your Honor, may I respond?
Go ahead.
The testimony is a product based on reliable principles and methods. 702C states that. I believe my witness has mentioned that he has used the proper methods and principles to come up with his conclusions.
Just to be clear, what evidence that you've establishes that this was that this method was reliable?
I established that he is a toxicologist. He is an expert in toxicology.
Remember, that's not the issue here. Whether he's qualified by knowledge, skill, or training, it's whether or not the method he used was reliable. So what foundation have you laid that establishes that this method he used was reliable?
It has been reliably applied and is commonly used amongst the community. Okay. If opposing counsel would do a quick Google search, they would know that this method is actually typically used amongst the community.
Well, just so we're clear, This has to be established by the witness in trial. So, okay, so you're saying that this is what other scientists in the community use. Plaintiff, what's your response?
And yes, Your Honor, it's true that opposing counsel, when they re-asked their question, that the witness did say that it was accepted widespread within the field. That's fine. However, we haven't heard that it's been subject to peer review, publication, or a known error rate. I ask that opposing counsel lay that foundation before they get into his conclusions.
Defense. So the opposing counsel is relying on tarot readers.
May I ask a question so my witness can lay the foundation?
Go ahead.
Dr. Cannon, can you tell us your expertise?
Expertise, yes. I have my MD in toxicology or my MD and emphasis in toxicology, and yes.
And do you have any publications?
Yes, I do.
And are any of these related to toxicology?
Yes, they absolutely are.
Now, may I continue with the conclusions that you arrived at?
Yes.
What conclusions did you arrive at today's case?
Yes, so I arrived at 4 conclusions in all. The first being alcohol poisoning, the second being the allergic reaction or possible allergic reaction, the third being hepatic disease, and then the fourth being pesticide poisoning.
Now, you mentioned alcohol poisoning as your first conclusion. Can you tell us more about that?
Yes. Well, according to the report, Genesis had a blood alcohol content that consisted of 0.16, and when Genesis was tested at the hospital, excuse me.
And what is BAC?
Yes, BAC is an acronym for blood alcohol content, which represents the ratio of alcohol to blood in their system in a system of a person rather. And I have a visual that can actually help if that works.
And how does BAC work?
Yes, so essentially, starting at the beginning of the slope, that's whenever the first initial consumption of alcohol, and it rises up until the last drink, essentially, where you reach the peak, and then it slowly goes back down as the body metabolizes the alcohol until there's no more alcohol left in the system when you reach the bottom.
And what was your expert opinion about Genesis BAC?
Yes, well, I have never seen a person die due to a blood alcohol content of 0.16, but Genesis's symptoms were consistent with something much higher. I believe this should have, I believe that at some point during the night, his blood alcohol content was much higher.
And what symptoms did Genesis have?
Like I mentioned, as noted in the reports, he had nausea, vomiting, slurred speech. But as we saw, and also in Angel's affidavit, he slumped over in his chair and needed help to their room, which is consistent with a BAC greater than 0.3.
And what does this mean?
It's typically at a level where there's a pretty significant impairment. There is a large possibility that he could have suffered from alcohol poisoning, although that's not the only conclusion, and I can simply rule out.
Passing the witness.
All right. Plaintiff.
Yes, Your Honor. Dr. Cannon, you're being paid $50,000 to testify today, right?
Yes, that is my flat rate, yes.
You're here today because you're scared you'll lose a major client.
No, I'm here because I was asked for my professional opinion as a medical professional.
Well, it's true that one of your biggest clients is a company that makes chemical pesticides, is that right?
Yes, but I wouldn't let that relationship affect my testimony.
Well, they actually told you before your testimony that you would lose their business if chemical pesticides were found to be Ms. Petrio's cause of death.
Yes, I was informed of that.
And you're here today testifying that Ms. Petrio's cause of death was not chemical pesticides.
That is true. I'm simply offering as many conclusions as possible because there is no degree of absolute scientific certainty given in the
Dr. Cannon, directing you back to my question, you're testifying today that the cause of death in today's case was not chemical pesticides.
I'm sorry, can you repeat the question?
You're here today testifying that the cause of death was not due to chemical pesticides.
That is, yes.
But you acknowledge that the facts of this case are actually consistent with pesticide poisoning, is that right?
That is correct.
So I want to talk about the theories that you mentioned on direct examination. Now, you believe that alcohol poisoning could have led to respiratory arrest?
That is true, yes. Yes.
But you'd agree that it's extremely unlikely that a BAC of 0.16 would lead to respiratory arrest.
I'm sorry, the signal cut out a little bit. Can you please repeat that?
I apologize. You'd agree that it's extremely unlikely that a BAC of 0.16 would lead to death.
Yes, I agree with that. Yes.
In fact, you've never come across a case where a BAC of 0.16 led to death.
Yes.
You've never seen a case of alcohol poisoning fatalities that happened with a BAC lower than 0.3.
Yes, but at this point, it had been a long time since Genesis had consumed any alcohol, so of course it was going to be lower than it could have been initially.
But you'd agree that you have no evidence to show that the what Ms. Petrio's peak BAC was.
Of course, because there's no way to determine that.
And you'd agree that this theory of alcohol poisoning doesn't account for the pesticide found in her body.
That is true, yes.
Now, you also mentioned that it could have been an allergic reaction, right?
Yes.
To something that she ate or drank?
Potentially, yes.
But it's true that you have no evidence to show that Ms. Petrio suffered from allergies.
That is correct.
And this theory also doesn't account for the pesticide found in her body.
That is correct.
Now, you also mentioned that it could have been an issue with her liver. Is that right?
Potentially, yes. It could have been, it could have been hepatic disease or chronic liver disease.
But it's true that that's extremely unlikely. Is that right?
Yes.
And that theory also doesn't account for the pesticide found in her body?
Correct.
So let's talk about what does account for the pesticide in her body. Now, you actually think that it's most likely her death was due to respiratory arrest from pesticide poisoning.
Yes, but there is no degree of scientific certainty that can for sure prove this.
Well, Dr. Cannon, I'm not asking you about scientific certainty or 100% certainty. I'm asking you that you believe it's most likely her death was due to pesticide poisoning.
Yes.
Pesticide from the Cara wine produced by Peony Estates?
Again, there's no way to prove that it was the Cara wine specifically. So,
Dr. Cannon, is it your testimony today that you do not believe that the poisoning was due to the Cara wine at Peony Estates?
I testified specifically that it most likely was wine produced at Peony Estates and not the car wine.
Thank you, Your Honor. I have no further questions at this time.
Any redirect?
Yes, a quick redirect.
Okay.
Dr. Cannon, what would happen if your company was to lose desk keys?
Yes, it would impact our business greatly.
No further questions.
Recross.
No, Your Honor.
All right.
May my witness step down?
Yes. Dr. Cannon, you're excused. All right. Anything further from the defense?
No, Your Honor. At this time, the defense rests its case in chief.
All right. We have roughly 24 minutes before all loss. How much time does each side have for closing arguments?
The prosecution has 7 minutes and 30 seconds. The plaintiff, sorry.
Give me a second, Your Honor. The defense has 7 minutes and 6 seconds.
Okay. Let's do a 5-minute recess. We'll reconvene at 32 p.m. Central Time.
Yes, Your Honor.
All right. Are both teams back?
Yes, Your Honor.
Yes, Your Honor.
And my co-judges?
I'm here.
Yes, sir.
All right. Excellent. All right. The defense has rested, so we can now proceed into closing arguments. Plaintiff, you may proceed.
Your Honor, I'd like to first ask that I remain any of the extra time for rebuttal.
You don't need to ask.
Okay.
You're free. Feel free.
Your Honor, opposing counsel and members of the jury, may it please the court. Unsanitary conditions led to unacceptable results. Throughout today's trial, we have seen many improper acts on behalf of the defendant Peony Estates. And while the defense has attempted to downplay those acts as simple mistakes or even offer convenient excuses, the simple fact of this case is that a life was lost at the hands of Peony Estates. It was the unsanitary conditions all throughout their establishment and their refusal to adhere to safety codes that caused the untimely passing of Genesis Petrillo and ultimately brought us all here today. Now, as the plaintiff, we bear the burden in today's case, and that was to prove by a preponderance of the evidence that Peony Estates is liable for negligence per se. Now, as my co-counselor, Mrs. Canales, explained in opening statements, by a preponderance of the evidence simply means that the case we have presented to you today must be found more likely than not to be true. And the charge of negligence per se requires us to prove three things. The first being that the defendant violated Safety Code 12-100, that the defendant's acts and omissions caused the type of harm that the code was intended to prevent, and that the defendant's breach of the code was both the direct and proximate cause of the plaintiff's harm. And today, we have done just that. So let's first look at Peony Estates' violations of this code. And this code was explained today on the stand by Inspector O'Keefe, as he stated how it specifically outlines how businesses are to avoid contaminating their products to ensure the safety of consumers. Inspector O'Keefe even provided his bucket list method to walk through his last inspection of Peony Estates. Members of the jury, we saw the multiple violations that were spread all across Peony Estates, and they come together to prove that they violated the code, specifically Section 2. Now, this code specifically outlines how businesses are to handle pests and pest control insecticide. So they specifically violated this code in three major ways. The first way is when head winemaker Austin Lewis did not take proper precautions in dealing with dangerous grapes. As was brought out on the cross-examination of Mrs. Lewis, there are dangerous grapes produced at Peony Estates because of chemical pesticides. And although she usually uses these precautions to get rid of the grapes, in 2018, she simply wasn't there. Thus, the 2018 grapes ended up in the 2019 production of Cara wine, and this broke the code. Secondly, there are multiple instances in which chemical pesticides are found in the kitchen area of Peony Estates. This puts food contact surfaces in direct harm of contamination and violates the code. Mr. Arnold had to tell Mrs. Marchini that chemical pesticides did not belong on her kitchen counters, and thus violates the code. And lastly, Inspector O'Keefe mentioned multiple instances in which he saw open cans of pesticide throughout the bottling area. And this puts food packaging material in direct harm of contamination and again breaks the code. So now that we have seen all the ways in which Peony had violated the code, we can talk about how those specific acts and omissions caused the type of harm that the code was intended to prevent. So members of the jury, that simply means that this code was put into place to ensure that no contamination of products occurred, so no consumer was harmed. It was put into place to protect individuals like you and me and Mrs. Petrillo. But because Peony Estates did not adhere to that code through their acts and omissions, they caused the contamination of their wine. So first, this is seen again in Mrs. Lewis's failure to get rid of these dangerous grapes. Because they were not discarded in 2018, they ended up in the production of 2019 wine and thus in the bottle of Cara that was given to Mrs. Petrillo. Secondly, because there were open bottles of chemical pesticide in the winery bottling area during the year 2019, that means they were directly around the Cara bottle while it was being bottled in 2019, again leading to the contamination of this product and doing what the code was intended to prevent, contamination of a product. So now that those two prongs have been established, we can finally talk about how the defendant's breach of this code was both the direct and proximate cause of Mrs. Petrio's harm. Now, to put this more simply, members of the jury, that simply means that had Peony Estates followed safety statutes outlined by this code, that Mrs. Petrio would be happily married and still with us here today. However, they did not follow that code. Now, it's not argued that Mrs. Petrio passed away from chemical pesticide poisoning. As it can be seen in the toxicology and laboratory testing result, isofenfrose was found both in the stomach contents of Mrs. Petrio and in her blood. And isofenfrose is an organophosphate pesticide. Further, Mrs. Petrio's death certificate even states that the cause of death was organophosphate pesticide poisoning, and goes on to say that it was likely from the wine that she received at Peony Estates. Members of the jury, Peony Estates had a legal responsibility because of this code to not provide contaminated products to their consumers. Yet because they broke that code, a contaminated product was given to Mrs. Petrio, and thus she lost her life. That is both direct and proximate cause on behalf of the defense, and they have to be held liable for their actions. It was because all of the unsanitary conditions throughout Peony Estates that we saw absolutely unacceptable results. The passing of Mrs. Genesis Petrio. Now, the defense is going to come before you and attempt to downplay these acts again. But I will return to reiterate that because they violated the code, they took Mrs. Petrio's life, and thus ask that you find them liable for negligence per se. Thank you.
Thank you. Defense?
Yes, Your Honor. May it please the court, Your Honor, opposing counsel, members of the jury, precautionary measures lead to preventative results. Only one thing was proven by the plaintiff in today's case, and it's that Genesis Petrio died on June 8th, 2019. They wanted you to believe that because Peony Estates failed to follow a health statute, Genesis died. But members of the jury, that's just not the case here today. In order to find Peony Estates liable, the plaintiff had to meet a certain burden of proof. However, they failed to meet that burden. Before going any further, I want to explain the law at play in this trial so you can have a better understanding of what exactly has to be proved by the plaintiff today. The plaintiff had to prove to you today that it's more likely than not that Peony Estates violated a health statute. And that's exactly, and this burden was, the plaintiff had to prove that Peony Estates' breach of a statute was both the direct and proximate cause of Genesis Petrio's harm. Now, direct causation simply means that Peony Estates' action or lack of caused Genesis Petrio's death. And the proximate causation means that Genesis Petrio's harm was a reasonably foreseeable result of Peony Estates' actions or failure to act. Members of the jury, they did not prove any of that. What they provided you instead was with a testimony of a witness who was willing to do anything to get a story. You heard from Lonnie Parras about how he was fired from, and he wanted a story. He was willing to sneak into restricted areas for only employees. And next you heard from Mr. O'Keefe, who told you that States wasn't violating codes. In fact, didn't find any health violations in the wine cellar, didn't find any health violations in the vineyard. And though he did cite them for health violations in general, still gave them the thumbs up to produce wine, to bottle wine, and to sell wine. And after Mr. O'Keefe, you heard from Sam Arnold, who even told you that Mr. Arnold was terrified that Miss Petrio's death was a result of the food that he served. Now, we as a defense didn't have to present any evidence here today. I could turn my camera off, turn my laptop off, because we as didn't have a burden. The burden lies with the plaintiff, and they must meet this burden. However, despite the plaintiff's failure to meet this burden of proof, we decided to provide you all with testimonies and exhibits that show that Peony Estate took precautionary measures that lead to preventative results. Now, today you heard from Austin Lewis, a Peony employee who's familiar with the winery business. Now, you heard from Mr. Lewis that Peony Estates always had an issue with pests and that they've tried different methods to resolve this issue, but they had to stick with chemical pesticides because the winery was located on a slope where it's very common to have pests. Now, today the plaintiff tried to paint chemical pesticides as a bad thing, but that's not always the case. If certain safety measures are taken, then they're fine to use. Now, Austin Lewis told you about the precautionary measures Peony Estates took in order to keep their customers and employees safe. She retrained employees and made sure to effectively communicate with employees as well. And next, you heard from Danny Francasio, the owner of Rosie and Pedro's Winery. You all heard from him that Harper Martini was having issues with pests. Now, despite the rocky relationship between Harper and Danny, Harper was willing to reach out to his competitor for advice in order to keep Peony Estates customers safe. Now, those are extra precautionary measures.
Your Honor, it appears that my co-counsel has internet issues.
Okay, fair enough. We'll wait for her to get back. In the meantime, I'll check with the tournament director to see if it's okay if we go a little over all loss just because of these technical difficulties.
Did I cut off?
We can hear you. At least I can hear you now.
Okay, I'm not sure where I got cut off. Do you kind of remember where?
Around when you were talking about Austin Lewis.
Okay, will there be any issue with time if I just continue talking from that point?
I'm going to check with the tournament director, but for now, just proceed with the rest of your closing.
All right. Today you heard from Austin Lewis, a Peony Estates employee who's familiar with the winery business. Now you heard from Mr. Lewis that Peony Estates has always had an issue with pests, that they've tried different methods to resolve this issue. However, they had to resort to chemical pesticides. Now today the plaintiff tried to paint chemical pesticides as a bad thing, but that's not always the case. If certain precautionary measures are taken, then they're fine. Well, today, Austin Lewis told you that Peony Estates took certain precautionary measures in order to keep customers and employees safe. He retrained Peony Estates employees and made sure to effectively communicate with employees in regards to using chemical pesticides. And next you heard from Danny Francasio, the owner of Rosie and Pedro's Winery. You heard from him that Harper Martini was having issues with pests. And now, despite the rocky relationship between Harper Martini and Danny Francasio, Harper was willing to reach out to his competitor for advice in order to keep Peony Estates customers safe. And finally, you heard from Dr. Cannon, a medical doctor who's an expert in both the areas of toxicology and pharmacology. Now, upon analyzing material given to him, he came up with 4 different possible reasons Jessica could have died. And one of them was alcohol poisoning. Dr. Cannon told you all about blood alcohol content. Told you that Genesis Petrillo could have displayed a higher blood alcohol content that could have led to alcohol poisoning. Now, Peonia Estates made a promise to keep their employees and customers safe the minute they opened for business, and they followed through on that promise. Peonia Estates has always taken certain measures that the quality of their services is up to the satisfaction of the public, while also taking into consideration safety. Now, by following through, they've made themselves a reputable business. Now, why would Peonia Estates Winery not only violate a health statute, but would tarnish their image? I'm going to provide you with a visual. Today, the plaintiff had a burden of proof to meet, which was that it's more likely than not that Peonia Estates violated a health statute, and that as a result of that, Genesis Petrillo died. Now, this bottle of wine represents what the plaintiff tried to do is fill this bottle of wine in order to meet this burden. What the defense did today was create cracks to prevent the bottle of wine from filling up. Peonia Estates never really got cited for anything in regards to the vineyards or the wine cellar. That's a crack. In fact, Peonia Estates was able to continue making wine, bottling wine, and selling wine. That's another crack. Peonia Estates made sure to retrain their employees and get rid of product that could have been affected by chemical pesticides. That's another crack.
Guys, but the defense is out of time for their closing arguments.
All right. Thank you, defense. Plaintiff, your rebuttal.
Yes, Your Honor. May I proceed? Members of the jury, the defense is not wrong in their claim that precautionary measures lead to preventative results. They're simply wrong in the claim that Peonia Estates took any of these precautionary measures. Throughout their case in chief, you were introduced to Danny Francasio, who only spoke about the multiple instances in which Mrs. Martini begged for help to deal with these problems that she had at Peonia Estates. You were introduced to Dr. Cannon, who agreed that the most likely cause of this death was organophosphate chemical poisoning, which came from the bottle of wine from Peonia Estates. And lastly, you were introduced to head winemaker Austin Lewis, who admitted that the precautions that she usually takes prior to 2018 were not upheld in 2018. Thus, the production of the 2018 wine, the 2018 grapes, caused the contamination of 2019 car wine. Members of the jury, you've seen that Peonia Estates violated the code. Simply, the defense does not argue that point. And as the plaintiff, we have proved the 3 prongs of negligence per se, that they violated the code 12-100, that their acts and omission caused the contamination of their 2019 wine, and that their breach of the code caused the passing of Mrs. Genesis Petrillo. It was because of the unsanitary conditions all throughout their establishment that Mrs. Petrillo lost her life. And we cannot simply let Peonia Estates walk away without being held responsible. It is because of these reasons that we ask you, the jury, to find Peonia Estates liable for negligence per se. Thank you.
All right. Thank you all very much. I'll just take a few moments for my co-judges to submit their ballots. Co-judges, do let us know when you're done.
I'm ready.
Chandler asked if everyone could come on screen and maybe put their real name in the chat if you played a witness.
I'm pretty much done, so we could probably start with comments while I finish up submitting.
Okay. Well, how about we do this then? I'll have my co-judges introduce themselves. I've been talking for a lot already. Adan, why don't you go ahead and introduce yourself and maybe give your comments?
Hi, everyone. I'm Adan. I'm at Baylor Law right now, and this is my second time judging a mock trial tournament. As far as comments go, I would say there were a couple instances of preparedness and precision, and a lot of you were able to correct yourselves after the fact, which I really appreciated. That showed a lot of growth. But in preparing for the cases, I couldn't tell if it was that you had a hard time thinking of the way that the other side would see your case, or if it was just a lack of preparedness in the first place, which made me question what was going on. So be aware of when you're going through and when you're thinking of how you would present your case and how you're going to ask questions to the witnesses, trying to see like what an evil villain is going to object to or is going to raise a question about, or like your toughest, worst critic is going to try to poke holes in your argument.
All right, thank you. Chandler?
All right. Can everyone hear me? Okay, awesome. Hi, everyone. My name is Chandler. I am a 3L at Baylor Law School. Overall, I think you all did a good job, especially adapting with Zoom and everything. It's a weird year. Practicing attorneys are having to do the same thing. I wrote down some quick notes, so I'll run through them real quick. I know it's in the middle of the competition, so take this with a grain of salt. I didn't love either of y'all's themes. The problem with really catchy themes, and I know people try and do it in mock trial, is they're very easy to flip. So for example, at the very end with the precautionary measures lead to preventative results, you saw the plaintiff's side immediately flip that by saying, where were the precautionary measures? It's catchy, it's alliterative, but it doesn't do much. And it just leaves the jury thinking about, well, what does that really mean when they don't have the facts? You want to come up with themes. Same with unsanitary conditions lead to unacceptable results. That doesn't really tell the jury anything about the case. You want to come up with themes that are universal truths that you can then build on with rules that every juror can agree with, because then they're immediately on your side and it's harder to flip. So sometimes you have to sacrifice catchiness for effectiveness and things that won't harm your case overall. Let's see. I'm just going to try, for the sake of time, rather than get very specific and granular, give things that I think apply to every team. Have purposeful movement. You don't want to be so performative where you're having like hand movements that, you know, match the inflection of your voice, but that are distracting. You want to be purposeful and not take away from what you're saying based on what you're doing, because the jury will focus on that. Same with putting up things on the screen, especially during opening. If you're putting up documents on screen, it doesn't help you because the jury doesn't know what those are, and then they're trying to read the documents rather than listen to what you're saying. So be careful about those things. I've noticed with every team so far, you need to have precision with pronouns. It's better just to refer to parties and third parties by their last name. So there is total precision, because if somebody says he and it's actually a she, first the witness can call you on it, and that doesn't look very good. But also it's just not clear who you're talking about. So always refer to, you know, Mrs. So-and-so, Mr. So-and-so, so it's clear. I really don't like when people say, may I be heard? Nobody talks like that, and the jury's going to think, what is going on here? So if you want to have this, a lot of this is more for actual practice or just in general. If somebody says, may I be heard, or something like that, nobody talks like that. Just be normal. It will help you loosen up too. So that's my take. Something I notice a lot of people do, this isn't your case, right? This is your client's case. So don't say things like, I want to talk about, or I want to move to. You want to involve the jury and you want to involve your client. You want to be as removed as possible. You're the advocate. So say, let's talk about this when you're signposting, or let's move to this. When your witness is done, don't say, may my witness step down. You don't own that witness. It's either your client who you're paying, it's an expert who you're paying, or your client's paying you. It's either an expert that your client is paying, or it's somebody who's doing you a favor unless they've been subpoenaed. So don't say, may my witness step down. They're either doing you a favor or you have to have them there. Careful with objections. Make sure it's something you actually want to object to, or you should object to. If you just object right off the bat right away, everybody's gonna be like, oh, what's this attorney trying to hide? So if it doesn't help you, if it's not relevant, unless it's gonna go down a road that doesn't help you, maybe think about whether it's purposeful. On cross-examination, always try and finish on your themes, and that should help you all craft more coherent type themes that are universal truths. Because if you try and end a cross-examination on a catchy theme, it can be hard. Let's see, I know I've talked a lot. Let's see. On cross-examination, don't be a TV lawyer. No witness is gonna go up there and say, oh, actually, I'm gonna totally undercut everything I just said on direct and give you the answer you want. It's not gonna happen, and it's not effective either. If that happens, then the other lawyer should probably be sued for malpractice for putting that witness up there, right? I mean, theoretically, they couldn't be, but theoretically. So ask small questions with small answers that don't leave the witness room to maneuver or to equivocate. So for example, if you have an expert witness up there, you say to them, instead of just saying, you're here because you don't want to lose a big client, you start with something they have to agree with. Something like, you understand you're here today because the jury has to rely on your testimony. And as an expert witness, it's your job to be objective and unbiased. And if the jury were to learn anything that could affect your objectivity, that would be something they should know, right? And if they were to learn that you couldn't be objective, then that really makes your testimony less important in this case. All of those things they have to agree with. If they don't agree with those things, they sound unreasonable. And then that's where you say, and you didn't tell the jury that you have a client that you might lose if this case goes the other way. Now they can't disagree with that. And then you can come back and say, and you just agreed with me that they have a right to know about things that could affect your objectivity. So you want to tell your story on cross-examination and guide them through that story rather than try and poke holes in the things they said on direct. Last thing I'll really say, don't act surprised by the answers your witnesses give on direct examination. The jury knows that you know what they're going to say because you put them up there. So it comes across as really disingenuous when they say blah, 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 and you go, oh, wow. Or you say, you repeat it back with something of surprise in your voice, like, oh, wow, so you saw them do that. Well, you know that because you put them up there. And I think that's pretty much it. Don't give up on objections just to be polite if you don't feel like they haven't done what you need them to do. And listen to the judge, because sometimes the judge is trying to give you like a push in the right direction. I know with the expert thing that was going on, we kept talking, Judge Cruz kept talking about, what do you think about this case law? The answer was there, it was in the case law. You don't have to meet every single thing for reliability. That's what that case says. So be sure you know your case law so you can adequately respond. I think that's all I have, but good job, everyone.
All right, I'll be brief because my co-judges have already addressed basically all the ones that I wanted to make sure I made clear. One point that I didn't really have it, so I try to give as much substantive, really sometimes long comments in my comment sheet. So you get to see maybe more specific things. Unfortunately, I couldn't do that for every single person. But there's one space I didn't really have anything, I didn't have a chance to really put this in. It was in pre-trial, and kind of similar to the issue about tarot readers later on, where I was like, is that your understanding of the case? I said something very similar to that at the very beginning at the pre-trial, when we're talking about the 801D2D, the case law explaining that, and it wasn't that much of an issue really in this case, but as an attorney, you don't want to leave that open. So for example, in that instance where we were discussing that case law that explains employees' statements might be implicated to the employers under 801D2D, that doesn't mean that any statement by the employee is admissible under opposing party statement under 801D2D. So when I asked, I think it was the defense, is that your understanding of this case? Even if it wasn't that like a big point, you should have said, no, it has to be within the scope of their employment, their working relationship, not just any statement by the employee. Now, again, that didn't really come up as an issue, but as an attorney, you don't want to leave that open for the other side. Otherwise, if this became an issue later in the trial, I'm going to point to what you said in pre-trial and said, well, that's your understanding of the case, according to what you said earlier. One final thing about preparedness that I want to maybe hit on more a little bit is that when you're writing you're preparing your directs and crosses, you should already be anticipating the objections that the opposing side is going to make, or that you might want to make when the opposing side does those objections. So you should already be prepared to argue those objections ahead of time and know how you're supposed to respond to those objections. And if necessary, just work with other people on your team maybe to practice those objections, because the trial round shouldn't be the first time that you're making those arguments. You should already know what those are, and you should already know how to respond or how to make those arguments. So moving forward,
admissibility for every exhibit, every piece of testimony, you should say, here's how we're going to get this in. And so you should have a theory that you can fall back on. And sometimes it's 3 or 4, you know, you can say, well, this is present sense impression. It's also, you know, statement made in the course of getting medical treatment. So you need to have at least one. And if you're not sure if it's actually going to get in, have like 3 or 4 that you can go back to.
Exactly. And you should also have a backup for if the judge sustains the objection, how are you going to move on beyond this point without skipping a beat, basically. So that just comes with the preparation, and that's going to go more towards the next tournament. I guess you do have some time before the next round, and definitely before the 4th round. So definitely just keep practicing your presentation, your argumentation. I think everyone has a pretty good understanding of the facts. It's just, we want to go a little bit farther now, make sure that the presentation of it is just much better. All right. Any questions?
Thank you for judging.
Thank you.
Gracias.
Thank you.
Thank you. Thank you for your time.
Thank you.
All right. Thank you all. It's been a fun round.